Hello, I'm Bill LeMay, and thank you for watching Community Matters. We hope you'll continue to watch as we discuss issues facing our community and provide you with the resources and information needed to find solutions. We spend a huge amount of time online creating our virtual self. All that data is stored in the cloud, in Dropboxes, on our servers, and in online accounts too numerous to list. So with your entire life stored online, what happens when you die? Joining us now is Andrew Blair with Manning Fulton Attorneys in Raleigh. Welcome, Andrew. Appreciate you being here.
Thank you for having me, Bill.
I mean, we've heard a lot about this, and virtually everybody's online. And I mean, everything about everybody is online. And I never even thought about what it might be like if you die, what happens to it. So maybe just to give people an opportunity to understand what kinds of things are actually online and why we need to be thinking about this.
Well, it can consist of the things we know about in the front of our minds: email accounts, Dropbox accounts, Twitter, Facebook, etc. Even other things fall under digital assets. So you go to overstock.com because you want to buy something and you have to log in and create an account. Well, that becomes a digital asset of yours as well. And you have those that are yours in your individual name. From a commercial context, companies could also have their own digital assets, whether they have a Twitter feed, Facebook account, Google, etc.
I mean, I'm connected everywhere, and I began to think, even from my financial institution, online. Mm-hmm. I mean, everything I do now is virtually online. So what is mine and what is theirs?
You have a right to and it's a little bit different depending on the account, but for instance, with a social media account where you are posting content, whether it be words or photos, you actually have a copyright interest in those posts. Now, however, when you sign up for those accounts, in their terms of service agreement, they require you to give them an exclusive license to use that. So if you post something on your feed that's trending, they're allowed to take that and put it in a special place, move it. They can edit it, trim it, use it to help market their own services. But the information ultimately belongs to you.
So if I put a picture of myself and my family, or maybe I record a song or whatever it might be, and I put it up on Facebook, it then becomes theirs to do with what they choose?
Under a license. They don't take the ownership of it, but essentially, yes.
But in a sense, they can, right?
Correct, yeah.
Now, for folks who are, and we've had this happen, and this is why the discussion is taking place, people who pass on, eventually you do pass on. What happens?
Well, initially, the terms of service, when you first sign up, that click-through agreement that most of us don't read when we sign up for the account, will have some terms in it. And it used to be that no access would pass on to anyone else. Over the past few years, there's sort of been a lot more publicity around digital assets and what happens, and so things are changing. I'll start back. There was a gentleman named Ricky Rash in Virginia, and very tragic event. His teenage son committed suicide, and as any parent would, he wanted to try to find out, what had happened for his own purposes, and also to try and help potentially other kids that might be in that same situation. And he wanted to access his son's email accounts to find out if he could see what was going on and get some information on that. And Yahoo would not let him do that because their terms of service restricted that, and they were using privacy laws and so forth to back their position up. And so that, at least in this area, especially as he was in Virginia, was very pertinent and kind of brought some of that to the fore here.
That was one of the topics I know a lot of people are talking about, but I understand. On the other hand, playing devil's advocate here, I'm very sympathetic to the dad, but his son was an individual, and he may have things in his email that he may not want his dad to see. So for Yahoo or anyone else to say, this privacy is important to us, I understand that.
Well, and there are also federal hacking and privacy laws that would have restricted Yahoo allowing anyone access to that account. So the content in an email is considered confidential, and so Yahoo being a custodian, or Google or any other service provider being a custodian of that information, has certain responsibilities, and so they can't just give it to anyone that they want. It's protected information.
But I certainly understand the father's position as well. And if I lose
Correct.
someone I care about, if for no other reason because I don't know what's on Facebook page, you know what the sons and daughters are saying. It would be nice.
You may not want to know.
I may not, but you would want that. You would want that, would you not? I mean, whether it's just as a memory or to continue it on or what have you.
Especially in a situation like that. And so we've had some legislation recently. Well, there's been legislation proposed over the past few years, but North Carolina, for instance, just passed the Uniform Fiduciary Asset or Fiduciary Access to Digital Assets Act, called UFADA for short, to help put some context around that and set some boundaries about what an executor of an estate, a trustee of a trust, can do in those situations.
You know, and that's interesting because we know what to do, right, with those kinds of things, the house, the car, and things you can hold on to, and the law is pretty clear. This is brand new, and I'm assuming that all states, if not the federal government, are going to have to address this at some point.
And they have. There was an initial version of that law that came out in 2014 that was very fiduciary friendly, and it basically said if you have your letters testamentary or other document of authority as an executor or another fiduciary, you can go and get whatever information you need from that person's digital assets. And so the companies stepped up their lobbying efforts to fight that. They proposed a countermeasure or counterbill called PAC, the Privacy Enforcement Afterlife Choices Act, and neither of those two went very far. I think the original UFADA was passed in one state and PAC was passed in one state. So the parties all got back together and they created a revised act which met in the middle, let's say, and so that has received a lot more approval, and I think currently it's been enacted in 20 states.
What's the rationale of those who are maybe opposing that kind of legislation?
Well, they were worried about hacking laws, and so if I send an email to you and we had a private conversation and communication in that email, we haven't given consent to your children or my children or other people to view that communication. And so as a custodian, they didn't want to be held responsible if that information got in the wrong hands.
That makes perfect sense, actually. I mean, this is not an easy thing. Well, stick around. You are going to stick around because I got a lot more questions. We're going to take a short break, and when we come back, we'll find out more about how to make sure your data goes where you'd like it to go. So stay tuned.